All right, it's 12 o'clock. We'll get moving. Thank you so much, everyone, for joining in today's session. This is a webinar on H-1B registration and cap filings. I'm joined by Prashanthi Reddy. Prashanthi is a distinguished immigration attorney. She is an alumni with the University of Pennsylvania Law School, and she has been in the immigration field since 1997, admitted to the bar in New York, member of the American Immigration Lawyers Association and the New York Bar Association. Alongside that, she also holds the post of Immigration Chair for the National South Asian Bar Association and Immigration Co-Chair for the Federation of Indian Associations. She is actively involved in pro bono legal work, and we are excited to share the news that she is recently selected as a preferred partner by the government of Telangana in one of their incubator programs that helps and supports startups in the field of IT. So on that positive note, I will introduce Prashanthi, and Prashanthi, over to you.
Thank you all. I see people are still coming in, but we should, in the interest of time, start the presentation. Let's go to the first slide. By the way, guys, folks, today we're talking about H-1B cap season. Since it is cap season, so that's all we can talk about until cap season is over. But yeah, we're going to be talking about what to expect with the new registration. As you all know, registration has started already, and it's going to end next week, in fact. So all of you out there who want to file a new H-1, whether you're an employer or an employee, you should file your registration immediately. So I think it's important to talk about what to expect with this year's registrations, what is different with this year's registrations, and also a little bit about what to expect with reference to regulations, some upcoming regulation that is definitely going to be revamping the whole H-1B system. And it's important to talk about that now, even though it's still a proposed regulation. The reason it's important is because it will very soon become a regulation in some form or the other, and it will definitely affect the filing of the present H-1Bs. So, when we file now, we should keep in mind what regulations are coming up so that we can safeguard ourselves from any issues with reference to the new regulation. So let's jump right into it, Vishal. Let's have the first slide. Okay, first things first, we always touch upon the visa bulletin. If it's that time of the year, and it is, visa bulletin just came out a few days ago. And we all know what a visa bulletin is, but for those who don't know, the visa bulletin comes out every month. And the visa bulletin gives us an idea as to which priority dates are being worked on by the government for filing the green card. So these are immigrant visa petitions. This is the visa bulletin for immigrant visa petitions. There are different immigrant visa petitions. There's EB1, employment-based. Is just talking about employment-based today. There's EB1 category, EB2, EB3, EB4, EB5. That's an investor visa. EB4 is a religious worker. EB1 is multinational executives, extraordinary ability, people with extraordinary ability. Researchers, they're all EB1s. EB2 is people who, the jobs that require a master's degree or bachelor's plus 5 years. EB3 is all the rest, people who require a bachelor's degree or maybe less than bachelor's degree will be a skilled worker. So as you see, the different categories, and every category has a priority date. So when your priority date is reached, you can file a 485. That's the final stage of the green card. Your priority date is usually, you can look it up on the I-140 approval. The priority date is the date that you filed the labor in instances where a labor cert is required. That's the EB2 and EB3 category. In instances where labor cert is not required, such as in the EB1 category or in the EB5 or EB4 category, in those instances, you'll have to look at the I-140 approval to see what your priority date is. That's the date that you actually file the I-140. Okay, so that's what a priority date is. And let's look at the visa bulletin for April. For April, we'll be unfortunately using the final action date charts. Again, there's two tables in a visa bulletin. One is the final action date chart and one is the dates for filing chart. The dates for filing chart usually give you an indication of what lies ahead, and they are allowing you to file the 485 in advance. And usually it's, looks much better than the final action date. The dates for filing usually is used in the first few months when the new fiscal year starts. So the new fiscal year starts in October, and we've been using the dates for filing for October, November, December, January, February, and even March. But for April, now finally, we won't be able to use the dates for filing chart anymore. We'll have to use the final action date chart. So final action date chart is the dates that where they actually are. It's not advanced dates, it's where we actually are. So if you are current as per the final action date, you can not only file your 485, but also your 485 will be processed immediately. And if they continue to remain current, you will get the green card as well. So it's not an advanced filing. So let's look at the actual categories now. Let's look at EB1. EB1, as I said, was L1 based, so multinational L1A based multinational executives, or we also have researchers, extraordinary ability people. They're all L1. Also, people of extraordinary ability in the arts, in the business side, in the sciences, whatever it might be, and also researcher categories, those who are conducting research and whose research is helpful to the US. So for EB1, it's for EB1 India, it's actually advanced by 5 months, so that's good news. It's gone up to March 1, 2021. And it was 2020 earlier, so that's definitely an advancement. For China, it's gone up by 6 weeks. And all other countries, EB1 has remained current, and it is still current. So all other countries are countries other than India and China, really. That's all other countries. EB2 category, as I was saying, advanced degree holders. That is advanced. Also, EB2 is advanced by 6 weeks to April 15th. So that's good news again. It was March earlier, now it's advanced to April. China is advanced by 1 month, not much. And all other countries advanced by 7 weeks. So India advanced by 6 weeks, all other countries advanced by 7 weeks. And that has brought us to January 15, 2023. So for all other countries, the wait for EB2 is about a year, slightly more than a year and 3 months. For EB3 professionals, skilled workers, so EB3s are those professionals requiring a bachelor's degree, and those requiring skilled workers are those requiring less than a bachelor's degree. So China is the same, hasn't moved at all. India moves up by 6 weeks again, same as the EB2 movement, and all other countries advanced by 2.5 months, which is not bad. So those are the advancements. Next slide, please. EB5 is the investor visa category, and India and China and all other countries have not advanced. It's pretty much the same. For the also EB5, there's another category called EB5 set aside category, which is for EB5s filed from high unemployment and rural areas. Those remain current and have been current last month as well, and they remain current this month as well. So the outlook for the visa bulletin for the coming months, unfortunately, It's not looking good in the sense that it's going to be status quo. If that's good, then it's good. It's going to be status quo. There won't be much forward movement. So there won't be movement either way, I think, for the rest of the year, until maybe the end of the year when you might see some regression happening, some retrogression happening. The end of the year is September, so you might see some retrogression in August and September. But otherwise, I think what they're saying is that it's going to remain these dates until the end of the year, until the end of, say, August or September. Next slide.
Sure.
So that was the update with reference to the visa bulletin. Now let's move to the actual meat and potatoes of the topic. So that's the H-1B registration, the final rule. What is the, as we all know, the registration process this year, there's a new registration process with some brand new features and some brand new regulations. So let's see what the registration process is for this year. It took effect on March 5th. So we've already passed that date, March 4th, sorry. This year, the most important part of it that we should all remember is that the registration is going to be beneficiary centric. What that means is that they will pick the registrations based on the unique passport ID number. So, which means that no matter how many registrations you file as a beneficiary, you will get only one entry into the lottery system. And they will pick you based on the passport number, since you have only one passport number. And you're supposed to use the same passport number, even if you have more than one passport. So they'll pick you based on that passport number, and you will be entered once into the lottery. So no matter how many times you file your registration, now how many number of times you have registrations through different companies, which are allowed to do, you would only get one chance at the lottery. So this, in doing this, they have removed the incentive for a lot of people to file duplicate registrations. I think some people will still file duplicates because they want to make sure if company A doesn't file their H1, they want to have the option of going with company B, or maybe they want to see who will give a better offer and who will give better incentives and better benefits and go with that company. So that is good, but because it kind of fosters competition. So that's why USCIS has kept it there. It still continues to allow multiple beneficiaries to file multiple registration, as long as there is a unique job offer with each registration. So you have to have a valid, bona fide, unique job offer with each registration that you file. Okay, so as long as you have that, you're allowed to file multiple registrations, but you no longer have the incentive. The main incentive was that you could get a better chance of getting picked, but that's not there anymore. But if you still want to go ahead and file, please do. No one's stopping you. So that's with the beneficiary-centric registration process. As I said earlier, you need to provide a valid passport information, because they're going to be picking your case based on your passport ID. So last year, providing passport information was up to you. It was not compulsory. But this time, it is compulsory to provide valid passport information, and you have to make sure you have a valid, unexpired passport, and you have to make sure that you use the same passport to enter into the US if you're filing a new H1, a consular processing H1. And you definitely have to use the same passport to file your H1 when you're filing it. Now, say your H1 is being filed and the passport that you used expired and you need to use a new passport, then please make sure you submit both passports, both when you're filing the H1 and also when you're going to be traveling. Please make sure that you carry both your passports. And also when you're going to the consulate, by the way. So at any circumstances when you're going before the USCIS, Department of State, CBP, whatever it might be, make sure you carry the passport that you used to enter into the US. Very important. So, and also important to enter the correct information, passport information into the passport, and important also to enter only one passport. No matter how many registrations you're doing, you might have a passport of more than one country, but make sure you use only one. If you use more than one, then they will disqualify your registration, even if it gets approved. Even if your H1 gets approved, they will revoke it at some point. So please make sure you use only one passport. Don't try to game the system and use more than one passport, because that won't work. Another important update in this year's registration process and H1B filing process is there is a flexibility with reference to the start date. So you can put any start date which is within 6 months of filing of your petition. So it cannot be beyond 6 months. So the date that you file, the start date has to be within 6 months of the date of filing. And it has to be after October 1st. Previously, you had to put October 1st as the filing date no matter what. Even if you were filing after October 1st, you would have to put the start date of October 1st. Now, for example, if you file in June, you can put a start date of December. That is within the 6 months period. If you're filing later on in November, say, you can put a start date 6 months after that. That'll go into next year. You might be filing in November if there is a second lottery, for example. Otherwise, all cases have to be filed in the 90-day period starting April 1st, if it is based on the first lottery. So that really helps with reference to start date, because there are some students as well who maybe would like to continue with their OPT or CPT or student status and see it to completion, and then start their H1, or it could be that the employers require more time to start the H1. And also for students, another benefit is, staying on OPT for a longer period of time means less taxes. And maybe for the employers, it's beneficial because the prevailing wage does not have to be paid, though it has to be a fair wage. It doesn't have to be a prevailing wage if your employees are working on OPT. So there are many advantages of this delaying the process, but still wanting to file the registration beforehand, because that's always beneficial. I mean, because you want to file your registration as many times as possible, because you don't know when it'll get picked, because there is about a 30% chance of getting picked, and we'll come to that later as to what are the chances of getting picked this year and what is the outlook and how many registrations we're expecting this year. We'll come to that a little later. Let's go to the next slide. The other change that has occurred is that they've introduced and codified some integrity measures and given themselves, USCIS has given themselves the ability to deny or revoke H1s where the registration, either contained a false attestation or the registration was otherwise invalid. So as I said, like if you use 2 passports, that could be a reason for them to revoke your registration. If you do not have a valid job offer and it was a speculative job offer and, the employer filed, or maybe if the same employer filed through their sister companies for you, through different companies, that could be a problem, and that could also result in your registration becoming invalid. So, that's if they conspire together, if one company conspires with other companies and files registrations for the same beneficiary with the intent of improving that beneficiary's chances of being picked at the lottery, that could be a reason for revocation. So they've codified all this, and they're even earlier they would do it as a matter of practice, but now they've actually codified it because, in the past there have been lawsuits filed against H-1Bs that have been revoked, and now the chances of getting a lawsuit approved because it's now codified is less. It can still be done. A lawsuit can still be successful if they find that the regulation is unconstitutional, but it's harder to do. So that's the reason why they've codified their ability to revoke a registration or revoke even a H1 if it is based on multiple filings or an invalid registration. So a registration could also be invalid if the fee is not paid correctly or does not go through. It first goes through and the registration gets approved, but then later on the fee doesn't go through the bank and something happens and USCIS is not able to collect its fee, then that would be considered a invalid registration. And even if the H1B gets approved, then they could revoke that H1. So another important point in this whole registration process, the most important, I think, after the beneficiaries is the new organizational accounts that we have this year. All of you who have already been doing your registrations, you might have logged into your new organizational account. But for those of you who haven't done it yet, if you already have an account from last year, only companies can have accounts. So if you have an account from last year, then you should log in. And as soon as you log in, you will be notified to upgrade to the new organizational account. And it's pretty simple to upgrade. You just have to follow the prompts. Once you upgrade to the new organizational account, create more than one user. So that's the main key new feature that they have this year. So you can use more than one, you can have more than one admin, you can have more than one user. And also within your system, you can create more than one sub-accounts. So say you have 2 attorneys you're using, and you want to give access to one of those accounts to one attorney and another account to the other attorney, so both the attorneys can submit registrations or in the future submit H1s for you as well, because these new organizational accounts will be used for H1s as well moving forward. You can do so by creating these sub-accounts within your account. So that's another feature. Also, the new account will prompt you in certain instances where if you're finding a duplicate by mistake. So if you already have one batch of registrations that you've done and submitted, and then if you try to submit a registration for the same person again, it will prompt you that it's a duplicate registration. That wasn't there previously, and people by mistake, file duplicate registrations. So this year they have that feature in place. Within the list of registrations, though, if there is a duplicate, it will not prompt you if you re-enter another case with the same name. But there is a way of downloading the file in the system, and then you can check for duplicates. It's a CVV or something like that, Excel kind of file that will allow you to then look for duplicates. So just be careful. Last year, there was a company that filed registrations on their own. They filed a duplicate because they reversed the order of the name and they didn't realize that they filed the name twice. And in fact, the H1B even got approved. And after it got approved, they sent a revocation, a notice of intent to revoke, saying that it's a duplicate, and there's nothing much we could do at that point. So that's about the new organizational account. And the other feature, the cool feature about the organizational account is it's easy to invite your attorney. The interface has become much easier than last year. Last year, you had to go through a few hoops to invite attorneys into your account, or for the attorneys to invite you. Now it's a two-way process. The attorney can invite you into to collaborate, or you could invite your attorney to collaborate. And once they say yes, we will see your company in our accounts, and then we can very easily do a registration for you, and which will show up in your account, and then you can just approve and sign it digitally, and then we can submit it for you. So the interplay between the two accounts is much easier than it was last year. Next slide. Okay, online filing, another change, and I thought something we should mention. Not only, as I alluded to it earlier, but to give some more information, not only are we now able to do registrations online, but now we can actually file H1B petitions online. The H1B petitions for regular cases has already started as of February 28th. And for CAP cases, we'll be able to file online as of April 1st, because that's the first day that we can file CAP cases. I have not tried using online filing as yet through our office. We are still doing paper filing. As we all know, USCIS, or if you don't know, let me tell you, USCIS is not great where tech is concerned. They don't use the best and brightest that we have. They should come to me. Most of my clients are tech, and there are some very talented people out there. So anyway, USCIS doesn't have a great tech platform, so I will wait to use it. Even with the registration system, the new platform, the first day that we tried to use it, we had issues. We had a lot of error issues, and then we changed the web browser, and then it worked a little better. So, but the new online system definitely has its advantages if it works well. Also with, reference to the forms, we're used to using form software. And, if the form software companies come up with a plugin to the USCIS forms, then that'll work great, because then we don't have to duplicate our entries, because in the forms, sometimes they ask the same questions. And if we have to do, H1s for the same companies, then we have to enter the same information over and over again. So I don't know how that's going to work if I have to do it directly, do the forms directly on the USCIS website. But the good news is that if you do this and if it works, then we have approvals online, we have receipts immediately. We'll get a receipt online. And so that will reduce our anxiety with, mail getting lost by the post office. And when a receipt gets lost, especially, they don't issue duplicate receipts. If an approval gets lost, we have to go through a long process of filing for a duplicate approval. And it's very time consuming, money, everything. So it's very inefficient. So the online system will really help with, if we have these things online. Also, if you have a deadline, for example, and you need to file the same day, paper filings are all very difficult, almost next to impossible. A lot of service centers don't accept in-person same-day filing. And even if they did, having to drive to that service center, which might be in Vermont or Texas or somewhere else in a different state, definitely, is very cumbersome. So online filing will allow you to file for people who are expiring the same day, and sometimes that happens. There's some circumstances where, same-day filings become unavoidable. So that's a big plus. Another negative point for online filing is until they come up with other forms that you can file online. Right now, it's just H's. But when you have to file dependent petitions, the H4s along with the H1s, you can't do it. And we all know that there is a distinct disadvantage of filing the H4s with the H1s, because the H4s then get approved at the same time as the H1s. Otherwise, H4s take 6+ months to get approved. Now they'll get, for example, if the H1 is premium processing, you can file the H4 and it gets approved premium processing along with the H4 EAD. So that's a great big advantage. So, we will still use paper filings in those instances where we have to file dependent petitions. Another piece of information that I wanted to give you guys is the USCIS fee rule. The fee is increasing as of April 1st for almost everyone. The H1B basic fee is increasing from $460 to $780, so that's almost double. For L1s, it's increasing from $480 to $1,300. Your CAP registration fee will increase almost 200-fold from $10 to $215 starting next year, because it starts April 1st and we'll be done with registrations for this year. So starting next year, your registration fee will be $215. Next slide. They're also coming up with an additional fee called the Asylum Program Fee. This is the fee that they're taking from H1s and I-140s employers. so that they can run their asylum program, because asylum program is a no-fee program. And this is definitely unfair to to penalize one sector to help another sector. I think the government needs to pay for this, not you guys and not you employers. So it's $600 in addition to the increase in fee from $480 to $700+. So if you are a regular company, then you are paying $600 plus about $1,000 more for your H1 starting April 1st. But there's exceptions for this. If you're a company that has 25 or less employees, then you are not paying. There is no base increase, so there's no increase from the 460. It remains 460, but you will be paying the asylum fee. But instead of paying 600, you'll be paying 300. So your fee increase for your H1 would be $300, as opposed to the $1,000 for companies who have over 25 employees. The fee is also increasing for premium processing. It's going up from 2,500 to 2,800 and something. So that's an increase of $300. And this also goes into effect already went into effect as of February 26th, actually. So that's something to note. Next slide. Very quickly, this is the information that you need to fill out. Nothing has changed from last year. It's the same information that you need to fill out. Name of the beneficiary, gender, whether you're selecting the master's cap or bachelor's cap, date of birth, country of birth, passport number. This year, there's no option to forego this. You have to fill this out. Next slide. Company information has to be filled out, same as last year. FEIN number, name of the company. Make sure you have your address and you have a commercial address. Don't use a home address here. So that's something to keep in mind. We could go to the next slide. Some more do's and don'ts. Make sure you use the same email address that you used for registration. Give that to your attorney. Mention the name of the beneficiary as per the passport. Use a web browser that works. As I was saying, the browser, sometimes some browsers are not working and some others are. We had issues with Safari, but Chrome was working. So just toggle between browsers if you're having issues with your registration. If you're getting error issues, that could be the browser. Clear your cookies as well, so that you don't have issues with the browser. Next slide. This is just a timeline for what to expect for the H1B cap this year. Started February 28th when you could create your new organizational accounts. March 6th is when the registration started. That was last week. March 22nd is when the registrations end. That's March 22nd noon. Please be aware that it is noon. It's not end of day. And I suggest that you do your registrations by this week if you can. Just make sure, please, that you do it sooner rather than later, because if you delay with registrations and you file them last minute, if something happens with your registration, you will not have the option to refile because the date will be over. And that's happened and continues happening with many companies every year, and then they lose their opportunity to file any new registrations or bring any new employees that year. So important to do it quickly. Another timeline is the April 1st is when you can start filing your H1s. June 30th is the last day to file H1. So you have 90 days to file. Next slide. This is just the registrations that were filed over the year. The first column is, of course, the year, 2021, 2022 to 2024. The total registrations filed, the eligible registrations, so the registrations that were not denied due to lack of fee, etc. Eligible registrations for beneficiaries. This is the single registrations, that is single registration filed. The next column is the multiple registrations filed. And then the next column is the number of registrations actually selected. So to give you a brief overview, the total registrations, single registrations has not changed much. It's been from 200 to 350,000 over the last 4 years. But because the multiple registrations have increased, the total number of registrations have also increased from 300,000 to 780,000 last year. That's because the multiple registrations, everybody filed multiple registrations. The number of multiple registrations last year was 400,000. That is half the registrations filed by multiple registrations. And consequently, if you look at the number of selections, except for the last year, which was crazy because of the multiple registrations, and the number of selections were 188 because they had to keep selecting people, because the people selected were not actually filing H1s because there were multiple registrations, or because they were not able to file because USCIS said that, if the same company, related companies filed, then that H1B would be denied. So that was the case in many instances of multiple registrations. So there were two registrations. That's why they selected so many, 188,000. Remember, the total number of registrations are only 85,000. But they usually pick more every year. But last year it was unusual. They picked that many because there were no filings. But in general, if you look at it, over the years, there's about 120 to 130 registrations picked. So that's about 20 to 30% chance of getting picked. And they usually pick more than 85,000 because they know a few people don't file. So they always account for that and pick more number of registrations. So this year, my prediction is that it will be the same as the previous years. So the number of registrations will be, about 200 to 350,000 registrations, keeping in mind, of course, market factors and the economy, etc. I think that's the prediction for me. And the number of the pick percentage will be about 20 to 30%. So that's my prediction for this year. Next slide. Very quickly, as I said in the previous, in the beginning of the show, that I want to touch upon what's going to happen in the future and in the near future, because there is a proposed H1B regulation, which makes a lot of changes to the H1. And if you're filing now, it could affect your present H1B cap filing as well. So important to keep these in mind so that when you're filing, you can file properly and avoid an RFE, avoid a denial. The first is that USCIS has said that you cannot require a general degree. They're clarifying this, and this is most of these are already in place, but they're further clarifying them and codifying them so that, again, people can't file lawsuits. So if you as an employer require a general degree such as a bachelor's in arts or an MBA, general MBA, for a position, then that position is certainly not a specialty occupation, because you should require a bachelor's in a specific field. Also, so there's some good points and some bad points about this proposed regulation. So that that it is what it is. So the good point is point number 2, where they say that even though a specific degree is required, it doesn't have to be a single degree. It doesn't have to be a degree. It has to be specific, but it doesn't have to be a single degree. So you can have a requirement for, say, bachelor's in computer science in a closely related field, such as math, etc. The only thing is that you have to show how it is closely related. So that's definitely a plus, because this can add many occupations into a specialty occupation. So you can do a H1 for many more occupations. This is opening it up. USCIS usually looks at a book called the Occupational Outlook Handbook, which is published by the Labor Department. And in this publication, what happens is, if the industry requirement is a bachelor's degree in more than one field, even though they're related, USCIS will often deny or RFE those H1s and say it's not a specialty occupation because it's more than one field. So this is good because they themselves are saying that more than one field can be requested. So we can look at the OH and see maybe it'll open up many more occupations where this might be a requirement, and in the past we couldn't file, now we can file. Also, I think a positive point is number 3, which says in the past USCIS would say that, you know, in order to file a H1, all employers should require a bachelor's degree. So in the industry, you know, most employers should require a bachelor's degree. So wherever, again, in the OH, it said that normally employers require a bachelor's degree, but some employers don't require, they would use that to deny the H1B petition. So they are verifying it now and saying it should be required normally, but it doesn't have to be always. It's very important that every single employer doesn't have to require it, but in general, as long as they require it, then it's a specialty occupation. Number 4 talks about H1B amendments. We all know that if you move work location, you have to file a H1B amendment, but this was not codified earlier. It was based on case law. Now they're codifying it again to avoid litigation in this area. Next slide. They are going to give existing petitions deference, which means that if you already have a H1B petition and you're filing an extension, they should not be sending an RFE out if it's the same facts and same petitioner, same job description. They should not be sending an RFE. They've been saying this often in their manuals, in their practice manuals, but they haven't always adhered to it. Now, if they codify it, then they have to adhere to it. So this is definitely a positive. Number 6, they're saying that you have to show that if it's an extension or change of status, you have to show that the person maintains status. So they want documentation showing maintenance of status when you initially file the petition, even before they, or if they request it in an RFE, we usually provide that information, but they want it beforehand. So this is especially important in an F1 scenario, to show that you're maintained your F1 status, you went to school, maintained full-time school status, or if you're on OPT, that you worked for the required number of hours. So this is important in that, especially in an F1 scenario. They want to completely eliminate the itinerary requirement, which basically in the past they would ask you to list all the employees that you're going to work for the entire period of the duration of the H1, which is 3 years. Now they're doing away with that. Another important change is number 8, which is your validity period on your H1. Sometimes, especially if you're asking for only 1 year, sometimes employers may only require 1 year. But if the H1 is taking longer than 1 year to approve, and this is often true if it goes into an appeal process, and then it gets approved on appeal. So from the date that it was approved, then the USCIS will automatically move that to 1 year from the date of approval. In the past, if it was approved and the date was over, then the approval would really become useless because USCIS would not move that approval date forward. So next update is for the F1. You see there are a lot of updates, a lot of changes. We don't know exactly which changes will be in this final rule when it's published, but we're expecting many of these changes will be in the final rule. So it's important to cover the important ones. So the cap gap benefits for F1, we know that people who file a change of status from an F1 to a H1, they're allowed to maintain status as long as their H1 is pending, or October 1st, whichever comes sooner. So they continue to maintain the status that they had when they were first filed their H1. So if they were on OPT when they first filed, even if their OPT expires while the H1B petition is pending, they'll continue to be on OPT. But the thing is that this cap ended on October 1st previously. Now they want to move that to April 1st of the next year, of the next when the next cap starts. So this is really beneficial because then they will never then fall out of status. Otherwise, come October 1st, if their H1 was not approved by then, they would have to go back to F1 status, take classes, or file a change of status. So it was very messy. So that can be avoided now because the cap gap continues. Next slide. This is very interesting, number 10. It's actually codifying the ability of a person owning a company to actually file a H1 for themselves. In the past, this was not possible, even though they said theoretically it was possible, but they would never approve these cases. Because when you own a company, you're doing a lot of administrative work, number one, and that administrative work is not specialty occupation work. And number two, it's difficult to prove that you have a valid job offer. There's difficult to prove the employer-employee relationship. Now they're saying, as per this new proposed regulation, that as long as, even if you own the company, and even if you own more than 50% and you're controlling party of owner of the company, you can still file a H1 as long as more than 50% of your work is specialty occupation, and even if the rest is administrative, as long as you have more than 50% of it is specialty work, you can still file a H1. This is a great advantage and a great option for entrepreneurs who want to start their own business and do not have a green card to be able to do so. So let's see how it plays out. I really hope that it finds its place in the final regulation. Number 11, and I think this is the last one, and then we'll open up the floor for questions. So whoever has questions, please start posting if you haven't already done so. FDNS Visits. This is FDNS. This is the body that conducts audits on your company once the H1 is approved, and you pay an extra fee for this. The $750, $1,500 fee that you're paying is for to fund these FDNS visits. So in the past, you could refuse an FDNS officer and if you not allow him into the office and refuse answering his questions, etc. But now they're codifying this, meaning that they're making it compulsory. In the past, practically, it was necessary to allow them into your office, because if you didn't, then they would just write a negative report and then, your H1 could get revoked. But anyway, they're codifying this. So now you have to allow FDNS officers to enter. You have to answer their questions if they're relevant. So site visits are now something that, is not discretionary, is not something that is up to you. So that's important to keep in mind. So next time you have an FDNS visit, if this rule comes into, becomes final, then you cannot refuse entry. Oh, another one. I'm sorry. Quickly,
Yeah,
this is important as
well.
I thought so.
Yeah.
Yeah, this is important as well. Very important that you have a bona fide job offer now. Even now, if you're filing a H1, last year we saw that a lot of skeleton petitions got approved, which means that if you're a consulting company, you filed without a PO work order, they got approved. But if this new law comes into place where they're saying that H1B has to be, you have to show a non-speculative job, and you have to show that you have specialty occupation work available for the petitioner. We don't know to what extent they'll take this. It might be they just want to see a PO and work order MSA for at least 6 months or 3 months, or they might want to see it for the entire duration, 3 years. We don't know, but I would caution you to file your H1 quickly so that you don't get affected by this petition. And even if you do, make sure that you have a backup, that you do have a job offer and you're not filing speculatively, just in case this law moves into place before your H1 gets approved. If it gets approved already, you have no problem. So my suggestion would be to file this year your cap case rather than leaving it for next year, because next year the chances of this becoming rule are much, much higher. And for those companies that operate from outside the country, I know a lot of you are in India and and other countries, and you don't have a physical presence here. You have a registered company and you're running your show out of India. Be careful, because they have they have a requirement coming up that you have to have a legal presence in the US, which might mean physical presence in the US where they can issue a service if needed.
All right. So the first question is there a way to transfer approved counselor processing H-1B without getting it stamped?
Yes, but in order to come into the country, you need a visa. So if you already have a visa and you are outside the country, but you cannot come in through that H1 for whatever reason, you can file another H1 with another company, and you don't have to go for stamping. You can use the stamping from your previous H1B approval and come into the country using your new H1B. So if that's the scenario you're talking about, then yes.
That answers. Moving on. There are two questions from this attendee. My H-1B was picked for fiscal year 2024 and petition got approved, but visa not stamped yet. Can I transfer my H-1B employer before visa stamping?
So H1B picked and petition got approved. Okay, so that means in this particular scenario, this person is cap exempt because they were counted towards the cap previously. It doesn't matter whether they went for a visa or they didn't. That does not make any difference to whether they're cap exempt or not, which basically means that since they previously were counted, you can now file another H1 to another employer and then go for visa stamping based on that second H1. So yes, it can be done.
Okay. And the second question is, since my H-1B visa is not stamped, can a new company file a new H-1B registration for me? And if picked, can it file a new petition for me?
So registration is not needed. So this question is moot, basically, because you don't need to file registration anymore. You are cap exempt. So you don't need to file the registration. And why should they file it if it's not needed? But can they file it? I'm sure they can, but I don't see what the need is to file a registration if you're cap exempt.
All right, next one. Can we study full-time once we are on H-1B?
Yes, you can study, but I don't know how you can do a full-time course being on a H1 because you might have to work as well. But there's no reg that prevents you from studying while you're on a H1.
All right, and the same.
But of course, people like to move to an F1 because there's some benefits to getting an F1, especially if you're full-time, because you'll get OPT, CPT, etc., etc. So yeah, but there's nothing to prevent you from studying while on H1.
All right. And the same person asks, if the employer seems to be legitimate when accepting the job offer and files H-1B, but later it turns out that the employer is not legitimate in USCIS I for some reason that employee is not aware of, then what are the repercussions that an employee / participant will face?
So it depends on what you mean by legitimate, not legitimate. There are many things that can happen here with the legislation. There could be multiple registrations filed in the way that's not allowed, meaning that they're conspiring together two or three companies to file your registration. You may not be aware of it, but they might be doing that, and that's not allowed. And if that happens, then your H1 will be revoked. But what repercussions for you? Are there any other repercussions? Meaning that if you leave the country and try to come back on a different H1, or you're going for a visa on a different H1. Recently, I have heard that, in the past, there have been repercussions for the beneficiary as well, though they shouldn't be because the beneficiary is not responsible for these registrations. But I've heard recently that Even lawsuits filed have been successful if they've been filed by beneficiaries, because the beneficiaries had no control over the situation. So in the same way, I think with reference to visa interviews, with reference to entering into the country at CBP, beneficiaries should not be penalized if something like that happens with their H-1B, and if it's the employer issue and not the beneficiary issues. So beneficiary has not done any fraud. For example, at the consulate, if you say something that is untrue, then that would be something that you would be penalized for. Then you might be prevented from entering the country for the next 10 years, etc. There might be a bar on you. But if this is something that the employer has done, I don't think you should be penalized for it. And I think USCIS is understanding this also, but we cannot guarantee that they will do that in every instance, that they will not penalize you in every instance.
Okay. Next one is, will an online master's degree with a US education institution that was completed by someone residing outside the US can be considered for master's cap? How to know if that very degree qualifies for master's cap?
Good question. And this might be a gray area. Thanks for asking it, Thomas. But in general, the criteria for master's cap is that you have to do a degree, and it's in person, right? So it's not an online degree. You can online degree doesn't qualify. So it has to be done from an organization that is either a public or a non-profit organization, and they have to be qualified as per CBIS to do it. So keeping this in mind, I would think that an online degree doesn't qualify for CBIS, number one, under the CBIS rules. And also, yeah, because of that, I don't think an online master's degree would qualify. They're not in the country. It's online. So I don't think they'll qualify under the master's cap. So I wouldn't do a master's cap for such a degree.
All right. Prashanthi, I know that we just have a minute. Are you okay taking a few questions?
Yeah, let's take the questions that were already asked. Yeah, let's go.
All right. So is multiple filing with different companies allowed for this year?
Yes, it's allowed every year. As I was saying, the beneficiary can file a number, as many registrations as they want to file, as long as each is a separate and valid job offer. If it's the same job offer that you're filing through different companies, say different consulting companies, but it's the same job offer through AT&T, it's the same job, then that's not allowed. Or if it's speculative, then that's not allowed. But if it's a separate valid job offer, then absolutely go ahead. Beneficiaries can still file multiple jobs, but the companies cannot file multiple registrations for the same beneficiaries, or cannot collude with other companies to file multiple registrations for the same beneficiary.
Right. Next one, what about non-lottery H1 filing? Can they do it throughout the year? Also, when changing companies, what are the requirements?
So non-lottery H1, yes, you can file anytime if you're cap exempt because you're working for a cap exempt organization, or you're cap exempt because you've been counted towards the H1 previously. You can file your H1 anytime during the year. When changing company, okay, so when you're changing the companies, it's a H1B transfer, so you have to show that you were previously maintaining a status on a H1. So this would mean that you have to show pay stubs and a W-2 if relevant, if applicable, to show that you're being paid the prevailing wage. Also, you have to show that you're working in the area that was approved as per the LCA, that your work location has not changed. If it's changed, then you need to file an amendment. So as long as you're maintaining your status and you are able to show that, you can file for a H-1B transfer any time of the year.
Okay, next one is progress masters doesn't count towards master's cap, right?
In progress master. So that means if you haven't completed your master's degree as yet, no, it's not. You have to have completed all the requirements towards your master's degree, which means that it means that you may not have the degree in hand, but you should have completed all the requirements. You may not have the degree in hand because maybe convocation hasn't occurred, maybe there is some tuition fee that you haven't paid, but as long as you have completed all the requirements, and remember, very important, that you should have completed the requirements as of the date of filing your H1, not as of the date of registration, because they have said in the past that filing the registration doesn't count as filing the H1, and they have said in the past in different situations that as long as you show that as of the date of filing the H1, you qualify for that H1, that's all that is required. Again, some people might say it's a gray area, but this is what I think with reference to master's candidates filing registrations.
All right, and we'll go for the last one. Do employers need to be e-verified to sponsor H-1B?
No, but if they are need to be e-verify, they're doing e-verifying for some of their employees. For example, they have students and they're doing an e-verify for their students, and they have to do it for everyone across the board, citizens, H1s, everyone. They have to follow the same policy for everyone. But if they're not doing it for anyone, then they don't have to do it for you.
All right. Well, I do see a few questions coming in.
We can go ahead and take them for a few minutes, Vishal.
All right, fantastic. I'll go to the next question. Are there any chances picking multiple registrations in lottery for same person, or will it be only one based on passport number, irrespective of number of registrations? I think you covered that.
Yes, no, you will not be picked multiple times. You will not have a chance of getting more than one entry into the CAP lottery filing. It's only one entry based on your passport.
All right. The next one is, can one smoothly change status from L2 to H1B working in the same organization, considering if lottery gets picked up?
Yes, you can file a change of status from an L2 to H1 as long as you've maintained your status on your L2, which means your spouse should have maintained their status on the L1. Absolutely. You don't have to leave the country. You can file for a change of status.
All right, fantastic. So yeah, on that note, we'll wrap up today's session. And once again, thank you so very much for attending this webinar.